the meeting that was held here, there was Rob Shearer indicated that the mayor expressed to him that the reason she was upset that they hadn't been able to figure anything out at the meeting or work anything out was because the Pulte representative had indicated that if they were able to build the roads for less money than it would require them to spend in January by waiting till July, that they might have additional money in the project budget to contribute toward the fire truck. And so that's what she related to Mr. Shearer based on his statement as to why, one of the reasons why she was trying to see if there was another avenue to get this worked out. After reviewing this allegation and these statements, even though these witness statements were difficult to reconcile, I concluded that the allegation did have some factual basis. There was a meeting. The mayor did request the meeting on behalf of Pulte. The mayor did indicate her opinion that the city should try to find some way to allow the building permits to be issued before the roads were built so that the road construction could wait until later in the year when the soil would be drier. Because I found there was factual basis for this allegation, I then looked at it in the context of the ethics ordinance to determine whether, under those facts, there had been a violation of the ethics ordinance. The provision in the ethics ordinance that is implicated here is Title 13-1-108. And that particular provision states, an official or employee may not use or attempt to use his position to secure any privilege or exemption for himself or others that is not authorized by the charter, general law, or ordinance or policy of the municipality. My analysis of that provision is different than Mr. Wright's. My analysis of this provision is that if that provision of the ethics ordinance is interpreted that literally, then there would be a great deal of the role that the elected officials in the city that they take that would be in violation of the ethics ordinance. I think that it is an overly broad reading of that provision of the ethics ordinance. The intent of this provision of the ethics ordinance is solely within the discretion of this board. I was not here when you passed this ethics ordinance, and I don't know what you intended when you passed that provision. But as a general matter, when courts look at statutes, they do not apply a statute in a means that is overly broad or unduly narrow if that would produce an absurd result. That's the court language there, absurd result. I think that if you interpret that ethics ordinance that literally, it's going to result in some absurd result. I'll give you some examples. If you have a constituent that has a difficulty regarding obtaining a building permit, and they contact you, it would be my opinion, if you interpret that ethics provision that broadly and that literally, that you could not then pick up the phone and call the Department of Public Works and say, my constituent over in District X can't get an inspector down here. Do you know when you can get one down here? You would not be able to contact representatives of city staff regarding any difficulties that your constituents were having, because you would be trying to secure a privilege for others that is not authorized by the charter, general law, or ordinance or policy of the municipality. That's why I think this is an overly broad reading of this provision of the ethics ordinance. You would not be able to change existing ordinances under this literal interpretation that Mr. Wright has put forward in his complaint, because you would be, by trying to change an ordinance based on an existing situation, you would be trying to secure a privilege for others that is not authorized by the charter, general law or ordinance or policy of the municipality. I'm trying to give you examples as to why I think that if you interpret that provision that literally, it's going to bring an absurd result, and a court, in my opinion, would not construe it that broadly. So based on that, I've concluded that no violation of the ethics ordinance occurred based on the facts that do support the allegation in paragraph 1B of Mr. Wright's complaint. Paragraph 1C. This paragraph of Mr. Wright's complaint alleges that Mayor Elam used her position to seek a waiver from staff on behalf of Mt.Juliet Commons from a condition which had been imposed by a vote of the City Commission and which City staff had no authority to grant. This by far was one of the more complicated fact situations for me to sort out, but it's actually pretty simple because the facts that underlie this allegation are related to a question raised by Mayor Elam in March of this year as to why one portion of a development was on the agenda for the Planning Commission and another portion of the development was not on the agenda for the Planning Commission. There was a good deal of confusion about some of the conditions that had been placed on the development by both the Planning Commission and the City Commission. There was a lot of questions that went back and forth about what the current conditions were, but the primary facts for this were that this board had put a condition on this development that none of the multifamily townhomes for this development could be built until the commercial portion of the development was completed entirely. This board put that condition on there. In fall of last year, one of the commercial parcels of this development had been sold, and the purchaser of that came to the Planning Commission to try to get approval. They could not get approval for the commercial development because the detention basin for the development had not been built yet. So Bobby Franklin actually, I think, described this best in that when he told me that what happened was the developer here had sold off pieces of his development, but because of the conditions that were in place, everything had something that had to be done before each piece could start, and someone else owned that other piece. And so it got very disconnected as to what had to be built first and when. But last fall, the commercial development was denied approval. In March, the townhome development piece was included by planning staff on the agenda for the Planning Commission. And the owner of that commercial parcel raised the issue, the mayor stated, as to why the townhome parcel was even on the agenda, because the commercial parcel had to be built first. And they had been denied because the detention pond had not been built first. So it was a very confusing sequence for this development. But in the end, what happened was the mayor had contacted Bobby Franklin and asked why the townhome portion had been put on the agenda, but the commercial portion had been denied and was not on the agenda. And the mayor came and appeared at the Planning Commission meeting in March and explained to the